Okay. Okay, the next case is Hernandez, MD versus Crespo. Whenever you're ready.
May it please the Court, good morning. I'm Dinah Stein on behalf of the petitioners, Dr. Hernandez and Women's Care Florida, and we're here on a conflict between the 5th District and the 2nd DCA in the Santiago versus Baker case, with the 5th District below essentially holding that under this Court's decision in Franks versus Bowers, parties to a medical malpractice action are no longer entitled to privately agree to arbitrate. And it is our position that this is a misreading of Bowers, that Franks versus Bowers still allows parties to privately arbitrate under the MMA, the Medical Malpractice Act, so long as the arbitration agreement incorporates all of the incentives, substantive remedies, penalties of the MMA. And that is the agreement that we have in this case, which precisely complies with this Court's decision in Franks versus Bowers.
So they have to, when they agree to arbitration, they've got to admit liability?
No.
No. So then that's what I'm having trouble, that if you don't adhere to the benefits of the Medical Malpractice Act, that is, by saying I admit liability, that all of the various aspects that were outlined, how this is different from Franks v. Bowers. I mean, obviously, you could, I would think you could come into a valid arbitration agreement where you say we're going to arbitrate, but then everybody retains their rights, and you're not arbitrating under the Act. But I don't know how, so how is this distinguishable from Franks v. Bowers?
There's a fundamental difference in what Your Honor just said. Franks versus Bowers didn't have statutory arbitration. It did away with it. There was no statutory arbitration. In other words, you went straight to the contractual arbitration, and that was it. And that's where there was no admission of liability. There was just a limit on damages. This has a huge difference, and that is this arbitration agreement doesn't even get triggered until the parties have the opportunity to mutually agree to statutory arbitration. So the parties are free in this case. In fact, they're required to go through pre-suit before the arbitration, the contractual arbitration comes into play. They are then required to determine whether they mutually agree to statutory arbitration. And if they do, this contract never comes into play. It's not needed because that's what the legislature wanted, the incentivize arbitration.
What piece of the litigation machinery, if you will, is replaced by the requirement in the contract to go through the Florida Arbitration Code?
I think I'm understanding Your Honor's question, just where in the statutes this comes into play, or where
okay, this contract provides for application of the Florida Arbitration Code after it goes through the preliminary things that you described, right? Correct. What does that supplant?
Okay, so this is what it supplants. Under this contract, the parties, again, pre-suit the opportunity to mutually agree to statutory arbitration. If they don't, that's where you get to the statutes 766.209 subsection 2. And I think that's a very important provision answering your question, because the legislature does allow for this for parties. And this is where you go off in two directions, because that's where it says if the parties don't mutually agree under the statute to arbitrate, then they go to trial or to any available legal alternative. And so that is where the parties part ways, with the non-contractual parties going.
So once they go to regular arbitration, then they retain all, other than it's not a trial by jury, they retain all their rights to, again, full damages?
Correct.
So there's no, so it starts, so there's no limitation on non-economic damages?
The only difference is the forum
Is that, but what I'm asking is, because I thought you said they don't have to admit liability, but the plaintiff has the right to, as if the Medical Malpractice Act didn't exist. Is that correct? In other words, it would be as if that they have, the plaintiffs have the right to full recovery of damages, but it's in an arbitration forum.
Well, let me just clarify, yes and no. If, let's say, the plaintiff rejected the defendant's offer to do statutory arbitration, the same penalties would apply in the contractual arbitration, and that would also apply the other way. If a defendant rejected statutory arbitration, they would be stuck in the contractual arbitration with those penalties. And I think that's consistent, not only that's in the contract we have here, but consistent with
I'm not sure I'm following you on that, because when I read this contract, the part of it that talks about the applicable law, that talks about the arbitration section, also goes on to say that also that it's applicable are the, the law governing medical malpractice, the law governing wrongful death, the standard of care, and caps on damages under 766.118. And so it seems to me that we are right back to, we're using the provisions of the MMA, but
no, and I disagree with that, and I'll explain why. This is just to incorporate Chapter 766 as if a party was in trial, and so when it says caps on damages, I mean, obviously, if this court's precedent changes the law as these contracts go along, no one is stuck with a statute to the extent it's, and I would concede there's some questionable as to the viability of some of, like, the cap statute. This contract isn't getting around that, and it's not intended to. Whatever this court's precedent is on caps, on the substantive law of Chapter 766, again, nothing changes except the forum. That's the only difference, is if one party goes...
How can you say that when it specifically states that it's subject to the caps?
Justice Lewis, this was drafted, first of all, this was drafted before, and I think agreed to, before any precedential decisions on this. But certainly...
It doesn't say, I mean, it says the caps.
Well, I left it over here. It says, all substantive provisions of Florida law. All substantive provisions of Florida law, I think by definition, means that it's, if there's a change in the substantive law, it has to be incorporated into this, and that's the intent of it. If the law changes, this can't predict
And in one
that.
other section it says statutory caps, does it not?
It says...
Including statutory caps, does it not?
Caps on damages under Florida Statute 766.118. Right. Well, now, if this court subsequently decides that that cap is no longer viable, certainly this court's substantive law is going to apply to this contract. That is absolutely in the intent of it. It wasn't intended...
But I guess the intent, here is what I'm still having trouble with. If the Medical Malpractice Act was providing an incentive to both parties to arbitrate and to make it less costly, and, again, the facts here, I guess, will get clarification, but I thought there was something about who asked for arbitration when under the Act. The thought that you then get, and I'll say it this way, another bite at the arbitration apple by, well, you didn't want this, now we're going to give you something really bad, we're going to make you arbitrate it, and you're going to still be subject to whatever, the Malpractice Act sets forth as limitations. And I somehow, again, I appreciate that that there may be a distinction. I just don't know if it's a distinction with a real difference from Franks v. Bowers, and that's what I'm struggling with.
And let me go back to Franks versus Bowers, because I think this court was clear that it's not it's not doing away with private arbitration agreements under the MMA. It's just doing it under those facts.
Well, I don't know that the court was, I don't know that we were clear with that. I mean, I think the idea that somebody here, it was a pregnant woman, or when it goes into a doctor's office and basically signs away her life, her rights, and then the question is, but she still has to go through the Medical Malpractice Act, and then if the doctor doesn't agree to that, she gives up her right to trial by jury. I don't know that Franks v. Bowers was saying, well, that second layers would be okay. Well, I mean, as opposed to someone just saying, listen, we're going to forego the benefits of the act, but what we want to do is we want to provide an arbitration forum rather than a court of law. And we're not going to have, you don't have to go through pre-suit, you won't have to go through, we're just going to do away with the act. And I don't think any doctors will want to do it. But that's not this situation. It seems like this is a double whammy for the patient. And explain why it's not.
Okay, it's not. And again, first of all, back to Franks versus Bowers, my understanding is that the court was a little bit compelled to find that there's still private arbitration agreements under the Federal Arbitration Act, because there's still a federal incentive to allow them, but the court was holding that it's got to incorporate all the provisions of Chapter 766. This agreement incorporates all of the provisions of 766, and this is not a double whammy. All this really does, it's not, there's no cap that you see in some of the other cases. There's no change in the standard of proof that we've seen in some of the other cases. There's no shifting of major remedies. The only difference, Justice Pariente, is that when you get to this subsection 766.209, subsection 2, where it says now you go to trial or any other legal available alternative, one group of plaintiffs who didn't arbitrate goes to court. The other goes to arbitration under the agreement that they agreed to. The damages, the penalties are identical. There's nothing, at least the damages provided under the Chapter 766. Plaintiff, and I say that because plaintiff has pointed out costs, which is not under Chapter 766. That's a civil procedure statute. That's it. And all that does.
How about the right to appeal?
Well, that's true, because then you go to, and again, the right to appeal is not part of Chapter 766. That's just part of jurisprudence, which the courts have recognized. It's okay to have arbitration and restrict that, because that's the point of binding arbitration. But that's, and the only, what this is trying to do is allow the parties to arbitrate without requiring them to agree to the statutory arbitration, which has very extreme remedies, because a plaintiff, this plaintiff says that, well, we should just incorporate the statutory arbitration.
Under this agreement, is there a limitation on what you can pay the arbitrators?
There is not. There is not.
And under this agreement, the DOA administrative law judges are not involved either, are they?
The two chosen arbitrators, I believe, pick the neutral arbitrator. But now we're going back to just arbitration principles. Are parties, private parties, allowed to privately agree to arbitrate? That's settled law.
I still don't understand how this how this agreement really differs from the Bowers agreement, and why when we say in Bowers, let me see if I can find that language, that if you are any contract that seeks to enjoy the benefits of the arbitration provisions under the statutory scheme must necessarily adopt all of its provisions. And so why is this not a violation of that principle?
And let me, I'll explain. In Bowers, the arbitration agreement, what it did was it adopted the beneficial penalties in the statutory arbitration. In other words, it brought in the cap from the arbitration statute without the admission of liability. And so I think this court reasonably said you can't do that. If you're going to have an arbitration agreement that binds the parties to begin with, you have to adopt everything. The difference is that here, again, whereas Bowers required that from the beginning, they had to engage with that arbitration where there was a cap but no admission of liability. We don't have that here. The parties can agree mutually to do the statute, in which case the defense admits liability. We didn't have that in Bowers, and that's a huge difference. And that keeps the incentive of Chapter 766.
But when you don't have the parties agreeing to the voluntary binding arbitration under 766, you get to this agreement, and this agreement incorporates some of the benefits from 766. Would you agree to that?
Let me tell you what I'm agreeing to. I agree that it incorporates all of the substantive provisions of 766, but when Your Honor says benefits,
well, isn't the cap on damages a benefit?
I'm going to have to disagree with this because what it says is all substantive provisions of Chapter 766, and then it goes into a list of things. And if Your Honors are saying, well, now maybe the substantive law is a little different, and you're keeping a statute that we may disagree with in there, that's not what this contract says. Obviously, whatever case law subsequent to a contract this court or any court comes out with is going to be binding on the parties under the provision where it says all substantive provisions of Chapter 766. And there's not an intention to get around any court's law with this. This was just a set of examples in the statutes of what applies, and this was drafted several years ago. So I think Justice Quinn sets a fundamental difference, is that this court was very, I think, clear that by forcing the parties into arbitration, contractual arbitration, with only the benefits for the defense and none of the benefits for the plaintiff, isn't going to hold. Whereas here, again, we've now gotten rid of that problem perfectly by saying, you know what, we're keeping statutory arbitration available to the parties, and we're just changing the forum. So again, I think if
you're into your rebuttal time, you're free to continue if you want to.
No, time goes by when you're having fun. I appreciate Your Honors actually granting oral argument in this case. It's important to us to have you hear us out, and I'll save the rest for rebuttal. Thank you.
Good morning. May it please the Court. Brian Gowdy from Jacksonville, Creed and Gowdy on behalf of Mr. and Mrs. Crespo. And I think what the MMA sets out is a very inexpensive arbitration or trial. And what we have under this arbitration agreement is inexpensive arbitration or very costly arbitration. So it's just changed completely the MMA.
Let me ask you a factual question first. Your clients had an opportunity to ask for the statutory arbitration, and they missed the time period for the statutory arbitration?
Yes, they missed the time period.
Okay. And so now we're left with having to arbitrate. And there's no question that they signed this agreement?
Well, actually, Mr. Crespo never signed it, but Mrs. Crespo, there's no question Mrs. Crespo did. And we briefed, and I don't want to spend a lot of time on it, but the first argument I heard a lot this morning sounds like the second issue in our case. It's a non-conflict, because Mr. Crespo never signed it. But Mrs. Crespo clearly did.
Okay.
And so, but the fact, I guess, is your we had another question. I felt it coming, but
my question then is, so now, at least as to Mrs. Crespo,
right,
she has agreed to arbitrate under this agreement that she signed, correct?
Correct, but like all agreements that are void for public policy, if they're void for public policy, they're unenforceable. So And that's no different than Frank v. Bowers.
But is there, now again, maybe we're getting sold a bill of goods here, but what has been argued here is it's different because it is, you can either go under statutory arbitration, but if you don't go under statutory arbitration, they're saying, quote, all we're doing is changing the forum. The plaintiff still gets to, again, subject to the malpractice caps, but not the caps of the statutory arbitration, gets to recover her damages. And so, first of all, is that different? It seems that it is different from the Franks v. Bowers. It may not. Is it? Well, is it different? And if it's different, is it still void against public policy?
It's different in that there's no express 250 caps as there was in Bowers, where they cherry-picked the 250 caps. We don't have that fact.
So that's but is that a big difference?
No, because in the court's opinion, and it was said several times, including on page 1247, it repeatedly noted all the benefits of MMA statutory arbitration. And the primary one that the court noted more than once was this admission of liability. And there's this portrayal that, well, it's just a different forum. But the thing that is appealing in general to plaintiffs about MMA arbitration is it's significantly less expensive. And just to outline then not just trial, but contractual arbitration. And there's a lot of benefits besides just the admission of liability that we don't have in this agreement. Under the MMA, the defense pays all the costs except for the fees for the ALJ. Under the MMA, that's not true under our contractual agreement. Under the MMA, the fees are capped at $750 a day. We had testimony here that the cost of 3 arbitrators, at $300 to $400 an hour is going to be far more.
But that's true of, I mean, again, we've gone through many years of thinking, oh, arbitration was just the best thing for people because it was going to be a less costly alternative, prompt, et cetera. There's been a shift about what this is doing to, rights to trial by jury. But we have not come to the point where we're saying, well, an arbitration agreement, because it's not as fair for the plaintiff, is void against public policy. So you have to be able to fit this in saying, because there's the Medical Malpractice Act, contractual arbitration is void against public policy of the Medical Malpractice Act, correct? That's the next. And I don't know that, and I'm with you in thinking this doesn't seem fair, but I'm not sure that you can make the leap to say that the second round, after the, if everything is the same, and I understand it's different, but then being able to sue in a court of law, some people think that is more expensive. Why is that void against public policy of the Medical Malpractice Act? Because
you've hit the nail on the head in that we have a very specific special statute regulating arbitration for medical malpractice only. So if I was here before you on an auto case or any other type of negligence case, I could not make these arguments. But the rationale of Frank v. Bowers is that when we're talking about medical malpractice, we're going to look at Chapter 766, not Chapter 682. So you would have to say that the intent, it's a different analysis though, you have to say the intent of the legislature was to supersede the arbitration code. And I cite this court's Maggio opinion from 2005, where you grappled with, when suing a state entity, you generally have to follow the pre-suit requirements under Chapter 768 to give notice, but when you're suing for a discrimination claim, you have pre-suit requirements under Chapter 760. And what this court said in Maggio is, you don't have to do both. You have to follow the pre-suit requirements of the specific Discrimination Act. It's the same concept here. We have a general arbitration code that will generally govern every piece of litigation except when we're dealing with medical malpractice. And the legislature wrote Chapter 766 to specifically regulate it.
So if, let's say the legislature had a specific provision in their medical malpractice statute that said there will be no arbitration proceedings that bring an action for medical malpractice, and they said that, can that stand scrutiny under arbitration law generally?
It would stand scrutiny under Florida arbitration law, because if the legislature says one thing in 682 and another thing in 766, then we would go with the specific provision in 766.
So it would be okay under the Florida Arbitration Code, but not the Federal Arbitration Act.
We're now dealing with the situation, but I want to be very clear.
Is that right? Is that your position?
My position is that the analysis is always going to be different when it's Congress versus the state legislature rather than the state legislature versus the state legislature.
So the answer to my question is?
I think if it's the way you frame the hypothetical, yes.
Well, that's no hypothetical. That's basically what you're arguing here.
No, it's not, because this issue did come up, the federal issue came up in Frank v. Bowers, and this court, in the opinion written by Justice Perry, explained the Volt, V-O-L-T, decision from the U.S. Supreme Court. And that decision on the Federal Arbitration Act talks about that if the contract specifically adopts state arbitration procedures.
Okay. I understand. So you're saying this case is different because they specifically adopt the Florida Arbitration Code.
In the contract.
And had they not done that, we would be talking about the Federal Arbitration Act. That's not this case.
That's right.
All right, so let me go to my hypothetical.
And if I could just add, they've never raised the Federal Arbitration Act at any point in this litigation.
Okay. Hypothetically then.
They have not raised it at all.
Hypothetically, if we were talking about...
Right, I'm sorry. I misunderstood.
If we were talking about the Federal Arbitration Act, then the scenario, if the legislature says no arbitration proceeding in medical malpractice, that's preemptive, and that cannot stand. You agree with that?
I think that would be... If it was that blatant, yes. If it was that express, it just said you can never have arbitration for medical malpractice, and I'm just going to assume, for purposes of your hypothetical, that it's interstate commerce.
Sure.
Then that would be very problematic.
Well, if you can't do that expressly, you sure could not do that in some implication way, right?
Well. But again, yes, you can if the parties decide in their agreement under Volt to go ahead and adopt the Florida procedure.
Okay.
So you might have another case later when someone raises the Federal Arbitration Act below, that never occurred, or where they write an agreement different than this one, or different than Frank v. Bowers. But they said right in here, we're following Florida law and the
what you're urging the court to do then is, under the Florida Arbitration Code,
yes,
that it's okay for the legislature to adopt any statute that says, in particular instances, that arbitration cannot lie in those cases.
Absolutely. The legislature could repeal 682 tomorrow.
Yeah, okay.
Partially, wholly, whatever, when we're only talking about Florida law.
Okay, I understand.
So,
thank you.
I wanted to answer your question, Justice Quince. I don't know if I've answered fully Justice Periente's questions, but I'll try to answer both. As far as the failure to timely seek, that doesn't change any of the public policy arguments. All that means is that if we had timely sought that when we go to trial, we would get certain sanctions under 766-209 because the defense rejected that. But because we didn't timely seek it, we don't get those sanctions. But that doesn't change the public policy argument that is from Frank v. Bowers.
But as I understand the argument that was made by your opponent is that nothing really has changed from that procedure. You're just in a different forum. So what has changed?
Well,
what is different about the arbitration under this contract that is different from the arbitration that would have taken place under Section 766.
I think her argument, to be fair to her, is that she's saying that there's no difference between contractual arbitration and trial.
Oh, okay.
And that
and
that
trial, except you don't have a jury.
Well, right.
And you don't
right. But I think
have an appeal.
And why I don't think that argument's right in Florida is that the legislature decided to make an arbitration scheme that is affordable. And this contractual arbitration is not. And it's not, she's saying it's just, and trial sometimes is unaffordable. But this MMA arbitration, if they had adopted this, is very affordable. And it's more than just the admission of liability, though. That's a huge part of it. Because if you have an admission of liability, there's a lot of experts you don't have to hire as a plaintiff. And then the defense, again, has to pay the cost. The fees are capped. The defense has to pay prejudgment interest. The defense has to pay attorney's fees up to 15% of the award. There's joint and several liability when we have more than one defendant. And as Your Honor pointed out, we get to do an appeal to the DCA via the Administrative Act. That's all under the MMA. That's none of that under the contractual arbitration agreement. So I hope that, I mean, she wants to make the comparison between contractual arbitration and trial.
No, I think, isn't the issue, though, whether because the legislature decided to legislate fully in the medical malpractice context, that, and again, I just want to make, that they intended to supersede the Florida Arbitration Act for medical malpractice. That's got to be your argument.
Precisely.
Okay.
That they intended to supersede 682 by providing that there be specific provisions under 766 on how you do medical malpractice arbitration. If you want to call everything I just read procedural in the forum, fine, I guess. But it really matters a lot to plaintiffs.
I mean, on the other side, thinking about this, if it had been the defendant who had wanted arbitration under the Act and the plaintiff didn't agree, then, as you say, there are certain detriments. But now what would happen is it's like a double whammy, right? Okay, you don't want this, but we're going to throw you into some place where you have, the Hotel California of the where you get nothing, you get no appeal, you get 3 people. I mean, again, some people might say it's better you get to pick one of your own arbitrators, but that's the point. Is that it's like you better do this first, but arbitration, because if you don't, you're going to do a second one that's going to be far worse.
You have arbitration or arbitration. Those are your two choices. And you only get, I'm sorry.
Let me see if under the Act, if both parties have to agree in order for it to be voluntary binding arbitration, correct?
Yes, okay. Your Honor.
So if one party does not agree, and there's no agreement like this, we're just in a trial situation.
Right, and if one party offers and the other party rejects, then there's certain sanctions.
Well, that's the point, is that the sanctions kick in.
They still apply here. We just get sanctioned. Let's say that they... that didn't, I mean, that's the hypothetical important one, that it could have happened if because from their point of view, it could be that they're thinking, okay, say it was timely and they reject it, what are the sanctions against the doctor for rejecting it if they go to if it goes to trial? What happens to the doctor? The sanctions then are prejudgment interest and reasonable attorney's fees up to 25% of the award. If we had timely offered arbitration and they clearly rejected it, but then we would have gotten those sanctions at trial. But they would say, well, you'd still get I think what I'm going to hear is they're going to say, well, you'd still get those sanctions the second. Right. So there is some incentive for us to agree to the MMA arbitration. Right, but they're not the same incentives that the legislature prescribed, and I just went through. So, I mean, you talked about in Bowers the balance that was struck. So, I mean, they've changed that balance through the through their agreement. Now, I wanted to be clear, you know, I think there still can be some private arbitration agreements. You could have what I call gap fillers that aren't covered by the statute. For example, could say that the MMA arbitration has to take place in Orlando. And I don't think that would violate the act. You could maybe also, for example, there's a range on the fees for the arbitrators. Perhaps the agreement could do that. There could still be agreements, but they have to be consistent with the MMA.
But the statute would, under your interpretation and the court's interpretation, precludes any arbitration absent a concession of liability by the healthcare provider.
Correct. That's correct. I think that's the interpretation of Franks v. Bowers. And then, you know, we've discussed, there's the Volt issue and federal, which could come up, but in these cases, both in Franks and in this case, it's not going to come up because this agreement complies with Volt.
On that issue.
And it hasn't been raised either. But
I understand your argument, but is there an opinion out of this court that says even in where a contract has chosen Florida law, as here, that the Florida Arbitration Code would apply unless it's in conflict with the Federal Arbitration Act? Do you remember any precedent along those lines?
no, I mean, I think generally when you're under Chapter 682, this court and the district courts of appeal have tried to construe Chapter 682 consistent with the Federal Arbitration Act. But we're not under Chapter 682, we're under Chapter 766.
Well, what I'm asking is where the contract specifies the Florida Arbitration Code as applicable, does the Federal Arbitration Act have any application at all, even if it's in conflict?
I think there's a whole body of, it's really hard for me to answer that really right now because I've read a lot of cases, but there's a whole body of, you know, U.S. Supreme Court cases about interstate commerce. But I think the Volt case is still the case, and it's still good precedent.
So under Volt, you would argue that it has no application?
Right, if the issue had been raised.
Okay.
Was Santiago wrongly decided, or is it distinguishable? That's the second district case.
It was wrongly decided.
They don't even, did it come out before Franks v. Bowers?
Yes. Oh, I'm sorry, after. No, they discussed Frank v. Bowers.
They do?
Yes. But it was wrongly decided, and I think they got hung up on what Justice Quince was asking me about whether a party, then there was apparently no, we did make a request for MMA, statutory arbitration, albeit untimely. There was no request at all. And Judge LaRose, who wrote the opinion for the court, I think kind of let that take him adrift and not focus on whether the agreement is void. If an agreement's void, it's void on its face. We don't get into what the individual parties did. And as I said before, I think my time is up, but that only affects the sanctions.
And I don't recall, in the Santiago case, do we have the provisions of that agreement? I couldn't quite see what that agreement actually invoked the substantive provisions of 766 or not.
May I have leave, Your Honor, to answer? So the defendant in Santiago and in this case is Women's Care. It's the same clinic. I don't think the agreements are laid out fully in either opinion. Ms. Stein did file in her appendix, I think, somewhere in the 5th DCA, the agreement that was at Santiago. That's from the Santiago briefing. And you can look at our agreement. As I said, it's the same defendant, and you would see the form agreements are very, very similar. I don't see any material distinctions, but they're not laid out in the opinions. But if you were to dig into the records of the two cases, it's the same agreement. Thank you.
Thank you, Your Honors. And the request for statutory arbitration, just to clarify in this case, came, I think, 6 months after pre-suit had ended, after this whole issue came up. And so I think the plaintiffs were just now trying to make an argument for the purposes of this, but there's a very wide body of law talking about time provisions in arbitration, and they were clearly untimely. As far as just generally, and you're not being sold a bill of goods at all. I mean, this is a very important distinction. We've gone through the distinctions as far as allowing for statutory arbitration here. As far as legislative intent, I think the legislature is very good at stating what it wants and doesn't want arbitrated. We've cited section, I believe it's 44104, which is the arbitration statute. Where the court, the legislature actually says everything can be arbitrated but these types of cases. Now the question now is, did it intend to supplant arbitration in Chapter 766? And I'd submit the answer is no, because first of all, it doesn't say that specifically. Second of all, the scheme that it does offer is a little bit, and I'm going to say extreme, in the sense that it puts in provisions that aren't normally required in a normal arbitration privately agreed contract, such as an admission of liability and a very low, a fairly low cap on damages compared to what they may be. So that was intended as an incentive to arbitrate. That's what the legislature was trying to do, is to get malpractice cases moving along, to take pressure off the courts, to make them maybe more palatable for parties. And so that's all the legislature was trying to do when it provided that incentive program, is to encourage arbitration. But there's certainly nothing in Chapter 766 that indicates that the legislature was saying you can't otherwise privately arbitrate. Now, as to the Santiago decision, I think what the court was looking at in Santiago was this court's language in Franks versus Bowers at 1249 and 50, where you do say it's fact specific, and that you're not saying that you may not have arbitration agreements, private agreements under the MMA. So it was a legal. I agree with Mr. Gowdy that was a legal decision. They're saying that the Franks versus Bowers case left that open, and that's all they were holding. They were rejecting the argument that we can no longer have private arbitration agreements. And finally, I think to some extent, Your Honor, Justice Pariente, you did hit the nail on the head as far as if the problems that they're complaining about are just your general problems that plaintiffs or either party doesn't like about arbitration, that's something that's been already litigated in many, many cases, and there's a different body of law on that. But these agreements are allowed. So I think in order for this court to find that it's not allowed here, it has to be because there's something contradictory in Chapter 766, the MMA, which is contrary to the legislative intent. So if Your Honors don't have any more questions, again, I appreciate Your Honors' time. Thank you.
Thank you for your arguments. Court's in recess for 10 minutes.
All rise.